Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, welcome back. Carl Rominger here. If you're just joining us, we're going to talk to you about a seminar. I've got AJ Palutis and, am I saying that last name right?
Palutis, that's correct.
Palutis or Pilatus?
Palutis.
Palutis. I think I'm saying it right, I just want to be sure. And Fred Haight, and that's not H-A-T-E, that's H-A-I-T. But I guess that makes you a hater, Fred. November 14th at 3 and 5 p.m. at 1 East High Street, and that's their offices in Carlisle.
That is correct.
Around here in central Pennsylvania, I'm originally not from around here. Originally from western New York, and maybe it's the same up there. I just haven't really studied it. Maybe everything's Buffalo Road. I don't know. But down here, every town has a high street. Every town has a Hanover Street. Mm-hmm. A lot. What's that? Yeah, and a Carlisle Street and a Harrisburg Pike, and yeah. So you end up, you can tell people it's on South Hanover Street, and they just assume whatever town they associate South Hanover Street with first is where you're talking about. So when we say 1 East High Street, we mean the Carlisle concept of East High Street, not the many other towns in the area where they have high streets. Because I don't think there was a single high street up in western New York. So you can tell whoever came and settled this area, and we know who some of them were because they're still hanging around, had certain words in mind. I'm just trying to think up in Buffalo, like if everything's called something. I don't feel that way. I mean, there's some Elm Streets, okay? They have a few of those down here, but I don't feel a lot of that. Anyhow, 1 East High Street, that's a lot of to-do about nothing, but I thought maybe you'd want to know about that. So you guys are workers' comp specialists, and as we established in the last hour, I can call you specialists because you have the appropriate certifications, which requires you to be more than simply dabblers. So I'm going to encourage anybody out there who's in the market for a workers' compensation attorney or has a disability law question or even has any kind of, I'm sure that they're not afraid of car accidents either.
That's correct.
Like all lawyers.
We're afraid of causing them. But.
Right, but not the actual. You ever read any John Grisham books?
Yes.
Yeah. Yeah, I like one of the most recent ones where there's a car accident and all the lawyers are out there fighting each other off with sharp metal for the victims of the car accident. It doesn't quite work that way, and it does say ambulance on your forehead from pressing up against it. Oh, so many bad stereotypes. Jay, you're on the WHP 580. What's going on?
Hey, Carl.
Hey.
I'll cut to the chase today. Gentlemen, I'm in my early 60s, spent most of my career working for the federal government, so I don't have a lot of quarters of Social Security, having paid in, other than Medicare. What I do have is probably part-time work from years ago. Maybe the last 5 or 6 years I've done some work. A lot of it was 1099 work. So, question is, I've come across, I've been ill lately, and I'm not sure I'm ready to call it quits. But my doctor had brought up disability. Now, I'm certainly not eligible for Social Security payments because I'm sure I don't have enough quarters. Am I eligible for Social Security disability?
If you have the rough answer, there's a more specific one that you can look up on the Social Security website. But basically, if you have earnings, if you have 10 quarters, 20 quarters out of the last 40, you would be covered for Social Security disability.
Okay. So in cases like that, where you're working for an entity where you're not paying Social Security and you have to go on disability, what do you have available to you? I don't know if I'm even available because I get an annuity. But if that weren't the case, and like say somebody works for the federal government or goes out on disability, is there some special non-Social Security disability or something like that?
Well, if you do not have any sort of a disability insurance policy, either that you have purchased on your own or that your employer purchases, there may not be.
Okay. It wasn't very far-sighted in those days. I assume employees now do pay Social Security.
My understanding is that federal employees now do participate in Social
Right,
Security.
I know that was changed in the 80s.
And, of course, if you were doing 1099 work as self-employed, that's covered by Social Security.
Yeah, I still don't know if I have quarters, but the point is...
Well, the way to find out is to apply. Yeah,
I guess. Well, like I said, I'm not quite sure. I'm hoping things will turn.
Well,
so we'll see.
If you said you're in your early 60s.
I'm in my early 60s.
Okay.
Yes.
If someone is 60 or older and cannot perform the kind of work that they have done in the past, that does meet the definition of disability for Social Security purposes.
Okay.
It's much more rigorous for someone under 60, but basically if you're over 60 and cannot do your usual occupation, you probably would qualify for disability.
Well, my occupation has kind of changed several times. So maybe.
Well, that sometimes happens to people too.
Yeah.
But if you have 20 quarters out of the last 40, you're probably covered.
I'm sure I don't, but I guess it can't hurt to apply.
It cannot hurt to apply. No. Now, for the benefit of for people who do not have enough quarters to qualify for Social Security disability, there is SSI available, but that's also means tested.
Yeah,
and if you have significant assets or you mentioned an annuity, you quite possibly wouldn't meet the means test for SSI.
Okay. Well, like I said, there's nothing ventured, nothing gained, and I'm not really sure I'm at that point yet. Anyway, so
Jay, you probably don't know this, but Fred is a bow tie aficionado.
Oh well. I hope it's a wild bow tie.
So he doesn't have one on today, but I'll put you guys together to discuss them at some point. All right?
Okay. Thanks a lot.
Take care. Bye. I know my callers.
Oh.
Roosevelt, you're on the air.
The most interesting lawyer in the world. How are you doing today?
Well, I'm discussing law, as I sometimes do, at 1 o'clock on WHP 580.
Hey, got two quick ones for you. I kind of got a little bit of the answer in the last call. I got two friends of mine, and I found it interesting. Both of them collect disability. One applied through a lawyer and got a lot of money, and the other one didn't get a whole lot of money. And I was just wondering, for the guy who didn't, could he just reapply with a lawyer and try to get a better rate? My second question, WHP is running a commercial where they say, for firearms, these people will show you how to get your silencer or muzzler for your weapon.
Right.
And I'm like, how can they do that, Carl?
Well, here's the dirty little secret, I guess. I always just, we always watch in the movies, they screw a silencer on and it's the bad guy because you can't have those. But the reality is owning a silencer or a fully automatic weapon is not as illegal as most people think, as long as you're willing to go through a little extra certification. So, as it turns out, I kind of laughed about the ad myself, too. Unless you want to, in case there's a stereotype for the listeners of WHP, silencer.com or whatever the name of that website is running an ad on here. But nonetheless,
they should do an ad on your program, man.
Right. Well, actually, we've got Sherman Tanks is going to be coming on shortly, and get your howitzers. Roosevelt, though, your first question was, so there's two guys with, are they on the same kind of disability?
Yeah, they both got back injuries.
And they're both on Social Security disability?
Yeah.
Having a lawyer would not make a difference in the amount of the benefit because that's based on the earnings record over your working life.
Okay.
Well, there we go.
So, okay.
Roosevelt, good question.
All right, well, that's one case where I guess you don't need a lawyer.
Well, here's the answer. The lawyer won't get you more, but sometimes you can't get through. And so I watched a special on, I should say watched on the radio. I was listening to National Public Radio. And on that NPR, they had this special about, everybody's laughing, but I'm probably going to get fired for saying that, but they had this special about who's signing people up for federal disability. And it's actually the states, and they're hiring companies to comb the welfare rolls and sign people up. But basically, and then the number two signer up is lawyers. And the reason is a lot of people, when you're disabled, first of all, you're having problems. You don't have a lot of money. Life sucks, all those sorts of things. So getting everything you need together, because the government strategy at Social Security is just to sort of deny you, right? You apply, they deny. You apply, they deny. You appeal, they deny. And so getting all your ducks in a row is the single hardest thing to do. And there's certain magic things that if you do this, this, and this. So basically what the point of this thing was that lawyers and these other agencies that work for the states have a 80-some% success rate of getting you on Social Security disability on the first try or two, whereas people who go at it alone have something like a 5% initial rate or something like this.
Okay.
All right?
I like the percentages with the lawyer a little better.
Yeah, I do too. All right, my friend.
Thank you.
540-0580. See you after the break. All right, we're back. 540-0580. I just want to remind you guys about RJ Gold. RJ Gold Auctions. He can buy outright or sell your items at auction. RJ Gold can be reached at 645-0061. That's 645-0061. He purchases outright items, as you know, medals, pins, patches, tokens, awards, badges, and historical collectibles. He can pay you right away. So if you have some of those things, you need some cash, you go see RJ. On the other hand, if you're looking to auction something off, you have a estate or a household, a moving sale, or even just a good selection of items, he is booking on-site auctions for November and December. You can call RJ Gold again at 645-0061. He's out of Harrisburg, PA, but if you can hear this signal and you have a telephone, I'm sure RJ will talk to you. AU005798, licensed auctioneer. Also, CDL Labor Logistics is seeking experienced, qualified commercial drivers with clean records for long-term, high-paying driving positions, both local and regional. In PA, Maryland, New York, New Jersey, call 866-293-1880. And again, when you call CDL Labor Logistics, you tell them Carl sent you. 866-293-1880. All right, so what are we talking about here? We're talking about all kinds of stuff, workers' comp related. Who's on line one, Shane? That shilly phone system is not showing me. Don, you're on the air. What's going on, my friend?
Gentlemen, good afternoon. I've been married for 22 years, and in the past years...
You want an award or a condolence? What do you want?
I'm sorry.
Right now, I want a little bit of both. My question is, the marriage has gone south, and I'm contemplating getting a divorce, and I was curious as to the financial implications, how much I can expect to pay in alimony. I have one child who's 11 years old, and how much to expect to pay in child support. If you can help me with that, please.
Well, wait a minute. You want to know how much you have to pay in child support? And which other kind of support? Alimony?
Yeah.
All right. Well, alimony is... What county are you in? Let's start there.
I live up in Allentown.
Okay, so you're...
Northampton County.
Yeah, Northampton County. So I have no experience with Northampton County. But I can tell you this. Every county is a little different, first of all. And because it depends on whether they use a master or not, and it depends on what that master's predilections or preferences are. And as a result, sometimes you'll see in some counties that there are very lengthy and arduous alimony awards, and you'll see in other counties where they're increasingly moving towards the modern trend of saying, if there's alimony, it's only going to be long enough for one of you to get schooling and get back to work.
Okay.
So, and alimony is always modifiable. So that in mind, though, let's talk about the more pressing matter called APL, or alimony pendente lite, or spousal support. And it doesn't matter which one, because if you can successfully oppose one, they'll just file for the other. And they're both based on the same formula. And they're going to be, for the couple with kids, okay, after you do the child support, it's going to be 30% of the difference in your net monthly incomes, okay?
Okay.
That's after the child support. So if you don't have any kids, it's 40%. Child support, you can look up the PA support guidelines online. The way you do that, you just figure out what your net monthly is and what her net monthly is, okay?
She has no net monthly because she's a stay-at-home mom.
Right. And how old's the child?
11.
11? You might be able to make a pretty good argument it's time for her to go to work, but maybe not right away. They may impute her a minimum wage, depending on work history, etc. But nonetheless, you can figure out what your income, monthly net income is then, and then just assume that you're going to be making 100% of that for the moment, and you can see what the support guideline for that number of children is per month. And then if you can impute her a little bit of income or convince them, you can add that on and take a look as well. So I can't give you an exact figure, but without knowing exactly what your monthly net is, et cetera, et cetera. But these are things.
So roughly 40% of my pay is going to go towards her.
Well, 30% of your net income, yeah.
Okay.
After the child support addition. So I go a little higher than I probably go a little higher than 40% of your net going that way initially, anyhow.
And for how long?
Well, APL or spousal support lasts until a divorce is done. Okay.
Okay.
Then we get into alimony, and again, an alimony can be all over the map. So basically, I'm going to tell you it's time to go sit down with a divorce attorney and run these numbers in a hard way. Okay.
Okay.
And don't stay married just because the math works, because you might just end up miserable.
Oh, it's already there. My other question before I go is, can she come back and sue in the future, say if I get a big pay raise in my occupation and she wants another piece of that? Can she come back and do that in the state of Pennsylvania?
Alimony, that is indefinite alimony that doesn't terminate, is always modifiable based on a change in circumstance. So the short answer is maybe yes, maybe no, depending on if the judge feels it's justified. On the other hand, as time goes on, you're going to say, hey, Judge, I don't know what she's been doing for the last 4 years, but sitting on her hands ain't helping anybody. And the judge may say, yeah, ma'am, you've had plenty of time to increase your income as well, so I'm not going to. On the other hand, she could slip and fall on the ice in the mini-mart parking lot, bang her head, and end up eating through a tube, and then maybe your alimony is going to go up.
Nice.
Right. This is why you never get married, all right?
Well, you're about 20 years too late with that advice. So
Right,
I appreciate it.
When we get the plutonium from the Libyans, we'll send Marty back with a message to your young self, all right?
Yeah, I need that. Thank you.
All right. 540-0580. Robert, you're on the air.
Hey, this is not really a question, but you guys have been on, workman's comp all afternoon. I would like them to tell the employees that they should go to their boss if there's even a slight chance it's going to get worse. If a guy falls, he hits his ankle, and then he says nothing, walks away, and then 2 days later he's in the hospital with a big ankle. He said he hurt it. Just tell him, report it to their boss and be sure he writes it down. And I think that whole area was not talked about.
All right, Robert.
That's all I got to say.
All right, I'm going to let you go, and we'll let them talk about it.
Well, we haven't talked about it yet, but you're absolutely correct. Any injury at work, no matter how minor you think it might be, should be reported to your employer. And by that, what I mean is reporting it to someone who is in authority over you, not just talking about it with your fellow coworkers. There are some very specific deadlines for doing so. If you do not give your employer notice within 21 days of an injury, you can't collect any benefits for any period of time before you do give the notice. And if you don't give the notice within 120 days of the injury, you are totally out of luck as far as being able to assert a workers' compensation claim at all. So no matter how minor you think it might be, or even if you think it may or may not be related to your job, give your employer notice.
It's also very important from the employer's perspective to receive that notice from the employee that they have been injured in any fashion, because workers' compensation is required to cover the medical expenses for the injured employee, and the injured employee must treat with a posted list of panel physicians within the first 90 days of the work injury. So for the employee to secure their ability to have that coverage, it's important to notify the employer immediately so that coverage can begin.
Yeah, years ago when I first got workers' compensation insurance for my law office, I got this nice letter from the insurance company that said that they could recommend a series of employer-friendly doctors for our panel if I wanted.
And you still can obtain that if you would like.
Yeah. In fact, there's a joke, and you guys know this, right? You go to a case, and there's some doctors that you usually see on the claimant's side, and there's some doctors you usually see on the employer's side, and the joke is like when they're reversed, then everybody gets really interested in why they're reversed. Like,
that's correct.
Oh boy. Now, Fred, what is notice to my employer? I mean, so if I just tell him orally, is that enough?
It can be.
So I say I told them, and they said I didn't. And I say I told them within 5 days of the thing, and they say they never heard about it a year ago.
Well, then when it comes up at a hearing on a claim petition because you had to come to a workers' comp lawyer to file your claim, it'll go to a hearing before a workers' compensation judge. You'll give your testimony. They'll give their testimony, and the judge will decide who or she believes.
So if I'm just guessing out loud here, if I'm allowed to email my employer, that might be a really good way to email my manager or somebody, or even if I tell somebody at work, follow up with an email later in the day or the next day or two just to memorialize something so I'll have some record to point at.
Well, putting it in writing is always best. Now, some employers will craft very specific policies that they will say that an employee must follow, and that say I've known of employers who say, well, you must fill out an accident report within 24 hours or 48 hours, or you don't have a claim. That's not true, but it is a good idea to have it in writing if you possibly can.
Okay. We're going to go to break, guys. When we get back, we're going to talk with Norm and Dan. Norm has a question about workers' comp, and Dan has a question about motion injuries. Sounds like repetitive strains or one of those great items. So 540-058, if you would get on the conversation. We still have some phone lines open, and we'll talk here with A.J. Politis and Fred Haight about workers' compensation law. And, of course, you want to visit their great website, which I've been looking at, by the way, as we've talked, and it is good. PAWorkersCompHelpNow.com. They've got a lot of articles up there. AJ has a blog on there. It gives him something to do when he's retreating from the stresses of his household. All right, see you after the break. You guys, I don't know if any of you guys watch movies or not, but you remember the movie Brazil? Kind of a artsy-fartsy piece. The protagonist in this story, his mother keeps getting younger and better looking as the movie goes on because she keeps getting, just younger and better looking. Yeah. And I just look at the picture of RJ here on the wall, and I always think of that movie Brazil when I see a picture of him.
Benjamin Button.
Yeah. He just gets better looking and better looking as he gets older, and I can't quite figure it out. But you get my glasses fixed. What? I actually think it's because he takes all the medicines that they advertise on the air here. But oh, good Lord. But we were taking a vote on whether to legalize marijuana during the break. And it was 3-0, but I'm not going to tell you what the vote was. Dan, you're on WHP 580 with Carl Rominger. What's going on?
I have a question about repetitive motion injuries. Workman's comp will cover those, but in my particular field, I don't have to say what I do, but pretty much everybody gets it at some point. You do the same thing day in and day out for 20 years. You're constantly using your arms, your shoulders.
My wrist is fine.
Like and you end up with carpal tunnel, but how do you prove that? Because they use your arms and shoulders for other things, and an employer can, and not 100% of the employees get that. So,
all right,
how does that work?
Well, basically, what it comes down to in Pennsylvania, there is the legal theory in workers' compensation of a daily repetitive trauma injury, and assuming that the worker is performing their work activities as you described, where there's constant repetitive motion of wrists, and let's say it's typing or it's using a jackhammer. Assumably, you're doing that for the majority of your waking hours. And what it comes down to in Pennsylvania workers' compensation is a medical opinion from your doctor that work activity has either caused the repetitive motion injury, and if it's in your wrist, let's say it's carpal tunnel, or even if you had some pre-existing problems with your wrists and your work activity aggravates that condition to a substantial degree, causing a new injury, and your doctor, after performing the appropriate tests and clinical evaluations, makes the diagnosis of that aggravation, then that is a recognizable injury under Pennsylvania workers' compensation law.
Well, here's why I ask that, because in most cases, the individual goes and uses their health insurance, and the health insurance company takes care of the carpal tunnel surgery or if it's torn rotator cuff or something like that. They take care of that. And then afterwards, you're left to the point where say, well, that actually was related to my work, and then it's almost as if you have to go about proving that. And I understand what you just said to prove that, but in the meantime, you're fighting over the insurance end of it too, which bills may have already been long paid by then. How do they sort that nonsense out?
Well,
it was a health insurance, it should have been a workman's comp, is what I'm saying.
Well, you hit the nail right on the head when you said should have been workers' comp. To make matters easier, if you had gone to your doctor originally and the doctor had pointed that out to the injured worker, that the work is causing the problem, then as we spoke to earlier, you would have notified your employer that you were experiencing a work injury as a result of your work activities. If you are still within a 3-year time period of the date of your last being exposed to the repetitive work that is causing your problem, you can still see a workers' compensation lawyer, and if the timing is still appropriate, you can file a claim petition. Whether or not the health insurance has covered the bills in the past is of no consequence to what needs to be covered going forward in the future. So you still have the ability to pursue that workers' compensation claim.
Okay, all right, thank you.
All right, my friend, thank you. 540-0580. Oh, did I lose my guy there, Shane? I don't know. Well, I think we lost somebody. Edward, you're on the air. Edward.
Yes.
You're on.
Hi. Carl, my question is regarding employment. My employer called me in for an emergency meeting yesterday and sat me down and forced me into signing a release saying that I would separate myself from employment, and they threatened to file charges with the state police for theft of corporate time if I didn't sign my voluntary separation form.
A theft of corporate time.
Yes.
All right. First of all, my employees are all going to jail. So,
what you should do is immediately sign up for unemployment compensation.
Okay.
Okay. Regardless of what you signed, the employer did not give you an alternative. It will be treated as a firing. And the employer, if it wants to contest your case, will have the burden of proving that you were guilty of willful misconduct. Now, as far as the theft of corporate time goes, Carl's the criminal expert. I'll let him speak to that. But as far as I know, that isn't found anywhere in the crimes code.
I guess if you were in the bonus gate case, that you'd have to use that theory of honest services, that you owe a duty of honest services to your employer or some such thing. But are you salary or hourly?
It was hourly, and they said it was because I was, at least one time I was 1 minute late according to the cameras, and when I signed in, I didn't sign in as that 1 minute late. And my argument was my watch time versus their camera time for just an example of 1 minute. But that's what they were using to force me to resign.
Lex something something de minimis something something Latin. The law doesn't trifle with small things. Okay, I could look it up, but they don't like us to use Latin anymore for some reason. Probably because none of us know it. But seriously, yeah, really, I'd like to see that brought as I'd like to catch. First of all, I'd like to meet the police officer that will file the charges for the company. The police officer is probably going like, so does this mean that if I'm 13 seconds late to report for duty, I'm now guilty of theft? Is that what they're trying to tell me I should arrest this guy for?
Or if service is a little slow at the Dunkin' Donuts?
Yeah, exactly. Theft of my time. They've stolen my time. And trust me, they've stolen my time. All right, we're laughing at you, right? But we're not really. We're laughing with you.
Right. No, I understand. But like I said, that's over that's close to $1,500 a month now that they just took from me. And it's not like I'd ever been in trouble with them before. I had never been written up, never even given a verbal.
Right, you're going to get unemployment most likely. How long were you with the employer?
I started in June, so I was still fairly new with the company.
Okay, and you have credits for unemployment behind that?
I'm sorry?
Were you employed before that for a while?
Yes, and this was my extra job, so I still have my regular job that I go to.
Okay, so you may have a partial unemployment compensation. But maybe you make too much already. I don't know how that works.
It could be a partial, but go ahead and sign up. You got nothing to lose.
Okay, thank you very much. I appreciate your guys' time.
All right, my friend. Tell us more about the seminar while we got a minute here.
Well,
I know I keep saying the seminar. They're going to have a seminar, folks. You can get your you get your personal questions answered.
We offer seminars to give people an opportunity to have their questions answered and to learn about workers' comp in an informal setting without any obligation or pressure. You can come for, typically they run about an hour or so, and you can ask your questions. We don't charge you anything. You can get to meet us. You get to size us up. It's a perfect opportunity to learn about workers' compensation without incurring any obligation or cost.
That's right, Fred, and also the big bonus of our seminar on November 14th in Carlisle at 3 and 5 at 1 East High Street in Carlisle is to meet the world's most interesting lawyer, Carl Rominger. He rarely wins cases, but when he does, it is always for millions.
He's been dying to say that all day. Oh, good Lord. But it's true. Rarely win cases. I like that part. Craig, can we cut that into an ad right away, Shane? Just that part. Craig, you're on the air.
Craig, did you say?
Craig. That's what I got.
Okay. Thanks for taking my question, Carl. My question is basically, what kind of protections do handicapped or workers that have had a health issue have? I mean, the employers could just find some way to get rid of them so they don't have the cost of carrying someone who could become disabled or drive up the cost of their health care plan.
Well, yeah, that's why you always ask the young lady right before you hire her whether she's planning on having any kids or not. But my question then for you would be, seriously, you're right, though, because there's always a theory, right, that sometimes when people are fired, they were actually fired because they were old, black, handicapped. And guess what? Employers actually do it. They just rarely say, I once had a case where they wrote the letter and said, we have to fire you because you're pregnant. Okay? Slam dunk, baby. I just didn't even have to go to the Human Relations Commission. I just wrote a demand letter. They took it to their lawyer in the poor restaurant. And the poor people were actually not trying to be bad. They just thought that because she was pregnant, it wasn't safe to have her working in the kitchen. Okay? That was their explanation. It still cost them 10 G's, all right? Point, though, is you rarely get that. So you're right. There's always going to be pretext. But I think that goes to what we've been talking about. There's going to be a hearing on it, and you're going to have to assert your rights, and the employer is going to have to justify their actions. Once you can show you're a member of a protected or quasi-suspect class, then the burden shifts to the employer to show a legitimate reason. I can think of one case we had with a woman who was very upset and thought maybe she was fired because she was a woman. But then you come to find out that her boss had fired like 50 people. And the defense was basically like, he's an, hole, and he has fired lots of people. But look, they're men and women. He treats everybody badly, therefore there's no discrimination. Anyhow, I just digress, but you understand what I'm saying. So the protection for people like that is going to be Obamacare, right? Because we're going to go a single-payer system. But let me segue. I'm going to let you go. We're going to segue here real quick. What about Obamacare? Let's go to break. Okay, we're going to break. We go back from break. We're going to talk about Obamacare, everybody in WHP land's favorite form of insurance. We're riding the crazy train or something here. All right, so we're going to talk about Obamacare because I actually had, and I mentioned to this you guys a minute ago, and that's what we got on the topic. I had a caller or a Facebook post, who knows anyway, they all blur together, saying to me, or maybe a text, I don't know, because, my personal phone number is on my Facebook page, and I have about 5,000 radio friends on there. So I get a lot of random texts from a lot of random people that hey, Carl, you got a minute? And it might have been one of those saying, why doesn't Pennsylvania just scrap workers' compensation, at least for medical? Because now that we have Obamacare, everybody can get medical help the minute they need it. Once the website's up, of course. But go ahead. Talk. What's going to go happen with Obamacare and workers' compensation?
The quick answer is Obamacare and the ability to go out and purchase health insurance that's now mandated does not have any effect upon medical coverage for work-related injuries through the workers' compensation system in Pennsylvania. And if you think about it, as most people do have health insurance, in the situation of a work-related injury, the health insurance carrier will typically deny benefits up front if a workers' compensation claim has been made. It is only when that claim is denied that denial must be shown to the health insurance carrier, such that the health insurance carrier once again becomes the primary responsible payer for that medical care.
And I assume, too, that there's a little bubble in there, too, which people forget about, which is assuming I don't have health insurance for some reason, and I'm just going to pay the penalty because I'm told that's going to be cheaper for some people, and just sign up when my cancer actually emerges. On the other hand, if the forklift flips over and I have some acute trauma care and no insurance, and there was no requirement that workers' compensation insurance exists, then I'm going to have a medical bill that existed before I signed up for my instantly available Obamacare, which will cover me going forward, but I would still have that, $8,000 helicopter ride and the $37,000 in trauma treatment that would have to be covered somehow.
Well, that's correct. If we did not have, in that particular circumstance, workers' compensation insurance already purchased for the employee by the employer,
right, then
you would be in that situation where you would have no coverage, regardless of whether you were able to go out and buy subsequent coverage.
So, in a nutshell, Obamacare is not going to displace workers' compensation anytime soon. But, Fred, you were kind of commenting that if Obamacare were to merge or become a single payer.
Well, right now, workers' compensation medical coverage is primary to every other insurance scheme as far as payment of medical bills is concerned. It's primary. By primary, what I mean is it is responsible to pay. Other forms of insurance exclude coverage for work-related injuries.
Okay.
If you're in a work-related motor vehicle accident, workers' comp is primary. Your first-party medical coverage under your auto care will not pay. That's workers' comp. If you are on Medicare, workers' comp is primary. Medicare will not pay for a work-related injury. Now, it's conceivable, and this is more of a pipe dream than anything, if Obamacare were to be replaced with a true single-payer system,
right,
like exists in most other industrialized countries, maybe we wouldn't have a medical payment component to workers' comp. But that's not what we have. That's not what we're likely to have. And Obamacare does not affect workers' compensation in Pennsylvania at all.
So let's just go back because we're going to run out of time here, but recap a couple things. First of all, if somebody's injured at work, the very first thing they should do is what?
Report that injury to a superior.
Okay. And try to generate some proof of that in case somebody wants to claim it wasn't reported.
That's correct. Typically, the employer will ask for an injury report, or there should be something as a follow-up, for example, a text message or an email, as you described.
And I would assume, too, since we have to treat with or go see the company doctor, so to speak, right away.
Well, if there is a panel.
Right.
There is not always a panel in every case.
Okay, and if there isn't a panel, then I can just go to anybody. But if there's a panel, I should go to who my employer wants.
Correct.
And, of course, even though I may be suspicious that my employer's doctors may be aligned against me for some reason, I can also know that by going there and reporting it as a work-related injury and reporting as on the employer's dime, so to speak, that's going to help validate that an injury occurred.
It does. It establishes notice. That is correct.
So then after I've made notice and somebody starts to tell me, well, you're fine, you don't really need workers' comp, or my employer starts telling me, I don't want you making a workers' comp claim, just we'll deal with it otherwise, or here's your short-term disability, use that. I don't have to do that. I can make a comp claim whether he wants me to or not, right?
Absolutely. In fact, if the employer who's telling you don't make it a workers' comp claim, he has committed an act of criminal insurance fraud.
Interesting. But how many times a day do you think that happens in Pennsylvania?
It happens many times. It's rarely prosecuted, but it happens many times.
And one other point, the employer, once that we've talked a lot about notice, but we didn't talk really a lot about what the employer's obligation is. The employer and their workers' compensation insurance carrier, once they are provided with notice of the injury, they have 21 days to respond to that notice. They can either accept the claim, they can deny the claim, or they can accept the claim on a temporary basis. And that is typically followed by the employer who does receive the report of the injury and properly reports it to their insurance carrier, because obviously they want to have coverage for this injury. And at that point in time, that's when controversy usually erupts, if it does. And that's when it's time to see a lawyer.
Okay. I got one more caller here. What's the name? I don't know. Eric, your name wasn't popping up.
Hey,
on my
how you
screen.
doing?
What's going on?
What's going on, Carl? Hi, everybody. Hey, I got a really weird question, and it sort of has to do with employment. I was offered a job from a large security company, home security, 2 weeks ago, and they were we were in contact and so forth. And they asked me, he said, "Well, tell you what, let's speed this up. Can you take a test for us so we can get you right in?" And they sent it to me in my home computer. I started to take the test, got my name in, everything else that they needed, and then it went to the test, and it was timed, only get 60 minutes, and my computer stopped it. I've been in telephony for 17 years. My computer said, "No, you're not doing this." I told them it wouldn't work on my computer. Can I come in and take the test? They said, "No, we have no facilities for that in our building."
Shoot it fast, Eric. I'm out of time.
In any case, they tried to download a program to take over my computer.
Interesting.
Are they allowed to do that?
I don't. Not only if you gave them permission. All right, guys. Thanks again for coming. When's the seminar and where?
November 14th. That's a Thursday at 3 p.m. and 5 p.m. at our Carlisle office at 1 East High Street, which is right off the square in downtown Carlisle.
All right, we're going to post that at seminar information to RomingerLaw.com. I'll put it on Facebook. We'll remind people between now and then. I guess I'm roped into going, so I know what I'm doing on the 14th in the afternoon. I'm not sighting my gun in. I am with my silencer.com silencer on it. All right, thanks. See you guys next week. God bless.